we've seen that the PPA has come into effect, which is the Property Practitioners Act. And as a layperson, I am now questioning, what is this Property Practitioners Act and how will it affect me? So I want to find that out. So now, what are your views on this act, and how will it affect everybody out there?
Well, first of all, Chris, I must say to the Minister of Human Settlements, ma'am, I really, really respect you, because you are making things happen at a massive rate, and the rest of us have to hold on to our hats for dear life, because we saw publication of the regulations on the 14th of Jan, already coming into effect on the 1st of Feb. So thank you so much for giving me a lot of reading. I had to really get into the regulations basically overnight, and already updated all the lease agreements. And we've already changed the TPN lease back, the TPN sales back, TPN residential lease back, to bring in and we'll discuss that obviously much more, but to comply with the regulations, to bring in the mandatory disclosure form, things like that. So we had to jump, and we thought we're still waking up in the new year, and the minister was like, okay, yellow for 2022, let me see you run. And I must say, I'm impressed, I'm happy. The act was promulgated in 2019 already. We were waiting for the regulations. Very quick promulgation, very quick effective date, with a cutoff on registration then on the 31st of October. So I think it's very good to start new legislation in the beginning of the year. I think a slight heads up on the regulations would have been kind, but then again, we're lawyers and we can work extremely fast. So that's my quick take on it, Chris. I'm very happy about the act. I'm happy about the regulations. I think it is an industry, one of the industries that aren't regulated in full, because the estate agents were regulated very well under the Estate Agency Affairs Act and the Estate Agency Affairs Board. We now, obviously, that's been abolished, and we now have the Property Practitioners Regulatory Authority, and bringing more property practitioners in under this umbrella, which I think is very needed, and very specific fines and sanctions in a situation where somebody acts as a property practitioner without a Fidelity Fund Certificate, FFC, and obviously protecting the consumer, but also the industry. So I'm very happy about it.
No, thanks, Cilna. Bruno, in terms of your understanding of it, I mean, what does it cover? And I know Cilna touched on a bit of that already, but how do you view that, Bruno, and the changes that are coming with this act?
So I've got, unfortunately, I've got a bit more of a confrontational view when it comes to the act. So not as positive as Cilna is, but that's why we balance each other out so well. My whole thing with the act is it's exactly that. The regulations come out. People aren't well prepared. Now, we've been waiting for the regulations to come out so that we'd have an understanding on how some of the shortcomings in the act were going to be dealt with. And that's my concern. When I read the act, and a number of people that I've spoken to, it took what we said about estate agents to a great degree, replicated it, not verbatim, but replicated what we already had in legislation governing estate agents for the most part. So let's say 70%, 75%, whatever. We're already dealing with Fidelity Fund Certificates. We were dealing with what estate agents were and weren't allowed to do, who could be an agent. There was training components to it. There's regulatory components. The biggest problem being that the effective management of the act and the EAB and stuff like that wasn't being dealt with like great. But I mean, there was a bunch of case law that came out regarding the EAB not issuing Fidelity Fund certificates, and it's not to criticize them. I mean, there were a lot of obstacles in the way of doing it. An introduction of a new act, though, and we've seen this from experience, just because you give it a new name and there's a new piece of legislation doesn't necessarily fix the issues that were there to begin with. yes, there are a couple of things in this piece of legislation that might make it easier. So, for example, now you only need to apply for FFC every 3 years as opposed to every year. So that might take some of the burden off the EAB, but you wouldn't need a whole new piece of legislation in order to say that. So a lot of this legislation, and here I agree with Cilna from a positivity side, it comes from the transformation component. So if people see that as a good thing, then it's a good thing. If people see that as a negative thing, it's a negative thing. That's a matter of opinion. That is a big component that wasn't existing before. And we can see that from the numbers of Black property practitioners as it stands at the moment, and the lack of growth in that space. But short of that, it's like the Estate Agency Affairs Act was taken, reworded, but then almost at the end, it feels like they threw everyone else under this umbrella of the act and tried to make it apply to people that it just doesn't make sense. So I've got like home inspectors asking me, well, what do I do? I need training, right? And you're like, yeah, you need training, but who's going to train you? Because you're the first of its kind. So there has to be some kind of exemption where you actually get registered. Oh, okay, but I need a Fidelity Fund Certificate. And in terms of the act, they did. And everyone thought, whoa, well, but how's this going to work? Like, this doesn't make any sense. What do they need a Fidelity Fund Certificate for? Then the regulations came out, and now everyone goes, oh, regulations. Thankfully, what do they say? There's still gaps, unfortunately. There's still many gray areas that we don't quite understand how they're going to function. And then it gets promulgated. The effective date is so soon after the regulations that it makes it difficult. And what I've seen now is most people are like, well, we don't know, so we're going to wait. The authority, so what used to be the EAB, is now basically, it's abolished, but it's really just transformed. So it's going to be the same people for now, and a lot of the stuff is being left to them. So now, in addition to everything else that they had to do in the past, they're also going to be responsible for laying out certain rules or their functions, their rules, and governing certain things themselves. So I'm worried that we're going to be looking a year down the line, a year and a half down the line. It's still going to be very gray. People still are going to have complete uncertainty. And that does worry me. So that's my view on the act. If I try to paint it as with a smiling face, but it is a concern.
Oh, thanks, Bruno. So I wanted to quickly find out from you, one of the requirements of this act now is a mandatory disclosure form. Can you please touch on that for our viewers?
I love the fact that that Bruno and I have conflicting views about the act, but I think that's the problem with me is my positivity is quite something to work with. So and the mandatory disclosure form is one of the big reasons why I am extremely happy about the act and about the regulations. Simply because, what the mandatory disclosure form says, so what the act and the regulations says about this situation is, before a property practitioner may accept a mandate. So I just quickly want to pause on mandate and property practitioner. So a property practitioner is defined as anybody who does something on behalf of the owner of a property for remuneration. So it's less what the title of your job is, it's more what you do. So if you are a managing agent in the context of a homeowners association or a body corporate, so that kind of managing agent, you are also a property practitioner. But at the same time, the whole situation of sourcing, and Bruno, I'm glad you're on mute now, and I hope your hands far enough from there so you can't interrupt me on this one, because I know you're going to disagree with me strongly on this one. But the fact that sourcing agents are now regulated under this act makes me very happy, because I think I'm impressed that you're nodding, Bruno. I actually thought you're going to throw a cup straight through your screen to me. But the fact that sourcing agents are now actually properly regulated makes me very happy, because I have seen a lot of sourcing agents, some of them amazing, and does amazing jobs for their clients, and other guys just takes the profit out of their clients' hands. And if they mess it up and they don't have the yield that they now promised the investor, they're just like, sorry, bad luck. In this case, we do have a Fidelity Fund at the back, protecting the consumer on the other side. So that's why I'm excited. The Act requires that you have a mandatory disclosure form about the condition of the property already at the time of mandate. Now, I have been pushing for mandate agreements, written mandate agreements, for the past 10 years of my life. And every time I say to an estate agent, guys, really, especially rental agents, sales agents are used to mandate agreements, obviously, because your sole mandates must be in writing. But technically, guys, if we think about a management mandate, how many agents can do the management of one property? Effectively, it is a sole mandate just because of the nature of the contract. And that will have to be in writing. And rental agents are very easy to say, I don't want to do a signed mandate. I am going to lose my landlord to another agent. Now we have a situation where you have an act to fall back on and say, Mr. Landlord or Mr. Seller, I need you to give me a signed mandate because I need this written owner disclosure, landlord or seller's disclosure form that's required by law. And this gives our agents the ability to have written mandates. And I promise you, we're going to see way less commission fights, and this is what we want. So the mandatory disclosure form is a disclosure form that discloses the full condition of the property. This does not do away in the context of rentals with your joint inspection, which is derived from the Rental Housing Act. It's a condition report, and you need to already do that at the time of mandate. So before you list a property as available for sale or for renting. Now, I have said this over and over and over before. If you're going to rent out a property as a landlord, or you sell a property, get a professional inspector in to inspect your property, because I promise you, you're not going to get into your roof to check if your roof is proper, if you don't have termites. Now it forces us to do that. And why I'm excited about it is the problems that we see on property litigation comes from exactly that. The owner doesn't really know what's going on in the property. Tenant rents the property, something bad happens, or you sell the property, foot stewards, and now there's a dispute on the application of the Consumer Protection Act or the type of problem that we've had. And I do believe it's going to be a painful teething process. And I agree with you on that one, Bruno. But I'm very excited to imagine life in about 2 or 3 years from now, where everybody is used to this and are doing proper mandatory disclosure forms. For our viewers' benefit, there is a standard document as part of the regulations. So you can either download it from gov.za if you search for the property practitioners regulations. Like I said, on the TPN lease pack, sales pack, we've already updated that. So if you don't feel like downloading stuff and retyping, just go to tpn.cosa and get one of the packs. The full document is in there. But I think the quicker you get used to it and the quicker you start using this document, the easier your life would be. Okay, now I'll keep quiet again. You can throw me with a cup.
Nice. On the mandatory disclosure, just so people also understand, so there's no requirement on the seller needs to disclose what he knows about. Now, obviously, in our law, there's always been the question of if a seller is actually aware of something and he fails to disclose it and almost intentionally omits it, you can hold him liable irrespective of whether there's footsteps or the like, right? Now, this disclosure form, that doesn't speak so much on the consumer protection component of it. So what happens? But the assumption with lawyers is, well, you're going to put it down on paper and you're going to sign it. This is a representation that you're making. But it's not that you've inspected it with the best inspectors and this is it. This is how the property looks and there's nothing more to it. This is what you know about. So people also just need to be aware of that when buying a property. This disclosure form, for all intents and purposes, is as good as an honest seller. so if the seller that you engaged with previously was honest and didn't know about something and an issue arose and he was upfront about it, the benefit of this is now it's in writing and it's signed, so there can't be any dispute later is exactly what was said, but it doesn't change an honest seller's approach. This isn't someone like a home inspector going into the roof. This isn't what this document is actually dealing with. Just so people understand, it's not ultimate protection. It is just like, just the condition that I know about.
Thanks, Bruno. Thanks, Cilna. Also wanted to find out quickly, there's now, but you guys touched on it as well, these certifications that are required. So for instance, the B-BBEE certificate, the Fidelity Fund Certificate. And as a complete layperson, I mean, in terms of a Fidelity Fund Certificate, what is this? Where do I obtain it from? Likewise, with the B-BBEE certificates, who do I approach if I'm a property practitioner? Where do I go for this? I don't know if Bruno, if you want to cover that, maybe Cilna, you can talk about so Bruno, you can cover the Fidelity Fund, and Cilna, the B-BBEE certificate as well.
So there's a lot. Basically, I mean, it's all encompassing. So Cilna can come in with her views on it, but basically, there's a whole bunch of requirements or disqualifications when it comes to whether an estate agent or a property practitioner can now register. And the ones that you're mentioning specifically to apply to get a Fidelity Fund certificate is the tax certificate and the BE certificate, right? Amongst a myriad of other requirements, these are two that stuck out quite a bit, stuck out for me, stuck out for Cilna, for a lot of people in the industry. Cilna, if you want to, you can comment on the BE one. For me, for example, the tax certificate, I see as a bit of a concern. People have valid disputes with SARS. People have tax issues. Imagine restricting someone's right to trade. And then we have to ask why. So yes, there's disqualifications, for example, that deal with crimes committed. And I mean, a lot of legislation deals with crimes committed, especially of a financial nature. But there's a logic behind that. If you're dealing with a trust account, and the trust account has somebody else's money, the last person you want managing that trust account is someone that at some point or another got convicted for fraud. Yeah, sure, you know what, it seems unfair, maybe someone turned over a new leaf or whatever the case is, but I kind of understand where they're going with it. The tax certificate I struggle with a little bit more, because there's no reason why a property practitioner specifically has any more need for a tax certificate than a lawyer, than whoever, like a legal advisor for a bank. It doesn't really make sense to me why it's. And also what I don't understand is there's no exception to this. So it's not as though there's something they're going, look, unless, if you apply, maybe we'll give you, if you can show that it wasn't an intentional way of defrauding SARS or not paying tax, that there's an issue or that you're behind or that there's a dispute, then I'd kind of go, okay, great. They're just trying to find honest people that have valid reasons why they might be behind with their tax. Not really here. So this one, yeah, the tax certificate, I almost foresee that this thing might be challenged, honestly. But yeah, we're yet to see.
Yeah, I agree with you on that one. It's the tax certificate. If there is at some stage a bit of a qualification behind it to say, like, unless you have a valid reason not to have a tax certificate. Now, say for instance, through 2020, 2021, as an estate agent, you couldn't pay your VAT, or you couldn't pay your provisional tax, whatever. And you now have an arrangement with SARS, meaning you have a valid letter from SARS saying, sorry, but we have an arrangement, they are paying it off. You won't get a tax certificate during that time. So that, I must say, I would have liked to see a qualification. But then also there's another thing that does bug me a little bit, exclusions of disqualifications. And it seems at this stage in the regulations, if you're not a citizen of South Africa or a resident, that you won't be able to obtain a Fidelity Fund Certificate. And I must say, I feel that's unconstitutional. And I'll say that outright. I already spoke to the minister to say, "Yuck, that was a little quick," but I'm just saying I think that's unconstitutional. But be that as it may, let's give it time and see what happens. But when it comes to the BEE certificates, I see everybody's freaking out quite impressively about it. I've even had an estate agent ask me, "Cilna, do I personally now need a BEE certificate for me?" And I said, "Bookie, I'm sorry to break it to you, but you're a white love. You won't be able to obtain a BEE certificate for yourself. But you know, even if you're not, it's for the company or for the entity. There are no minimum requirements. So if you are non-compliant, and you have a certificate to say, or you have an affidavit to say, "Oh, yeah, sorry, I'm non-compliant," or you are exempt based on your annual turnover, those affidavits. It's not clear from the regulations if that's going to fly, but it should theoretically, because if you're non-compliant on BEE, you can't have a BEE certificate. So I think what's happening is because they don't have, for that particular industry, a scorecard yet, I think there is too much integration now and necessary links that we need between the BEE-related legislation and this particular the Act and regulations. What I would recommend is, if you're an estate agent, you're running an estate agency for your business, get in contact with a BEE specialist, guys. See what you can do. See how you can get to a point of implementing BEE. It's anyway where we want to drive in a situation where this is one of the few unregulated industries when it comes to transformation. So I know a lot of estate agents were already heading in that direction, and this is what we want to see in the country. And I think everybody got a massive stick about this BEE one. But remember, this is one of the last industries that are unregulated when it comes to BEE. And I think a push towards transformation in this particular industry may very well be extremely needed. So I think, yes, there are things that seems a little, okay, maybe in practice this could cause a problem, but my suggestion to our viewers, and what I say to the estate agents that I work with and that I train, is do what you can to make it work. Don't kick against stuff that's not really kick worthy. If you need to get your BEE certificate, get your BEE certificate. If you struggle, talk to someone, let's make it work. You anyway need a tax clearance certificate for basically any business you want to do. So work towards that anyway, work towards compliance. If there are issues, I promise you it will be challenged and it will be resolved. So for the time being, see what you can do to make it work, rather than believing the entire act is going to fall flat on its face, because I can promise you that is not going to happen. I've seen on Facebook, on the different groups, I have seen quite a few people saying, "Oh, this is going to be challenged and it will be completely removed," and I can't see that happening. Might be amendments in portions of the act. There might be a delay on the effective date, but I must say we're on the 26th of Jan with the effective date, the 1st of Feb. My advice to all of you is get compliant and comply with the regulations as they stand.
Thanks, Cilna. Thank you so much for that.
And on that note, what you might find, and I've seen this before, I mean, we saw this with Poppy. If there's questions, if there's challenges, valid challenges, and Cilna is right, the act's not going to fall on its face. I mean, too much has happened. No one's just going to revert back to the previous legislation. It's just not going to happen. But yeah, be ready for the 31st of October. Start working your way towards it, because you don't know. Yes, there might be an extension, but this isn't necessarily a hopeful Bruno saying, "Oh yeah, there'll be an extension." I'm saying there may be. We've seen it before with Poppy, when people realize, sure, there's still a lot of work that needs to be done, still a lot of awareness, etc., etc. People, you know, if there's backlogs with the authority on submission of documents, there might be, but certain things I doubt are going to change. So the BEE certification, if suddenly they go, well, allow for the affidavit, you don't need a certificate, the affidavit's good too. things like that aren't going to impact the fact that, you need to start looking and make sure you know where you fall within that scope. Tax clearance. The reality is I'm completely against there being this restriction. And I mean, for most of the things that I undertake and that I help my clients with, this has never been a serious issue unless it involves things like going overseas or moving money abroad, or specific, very regulated industries where it's like working for SARS, for example. But the reality is you should probably get your tax affairs in order at some point or another anyway. If there is a dispute, I just feel bad for people that are stuck in the middle of disputes, or in the middle of court cases, or in the middle of payment plans, or compromise, or whatever the case is. And remember, so SARS payment plans can extend often from like 6 months to a year. They tend to be short, but not necessarily always. So this doesn't give all that much time for a person to raise the dispute, go through the dispute process, get into some sort of payment arrangement. That's my fear around that. But get going anyway. You're going to need to get going. So, let this be the push that you need to get your affairs in order.
Can I please just quickly clarify on the dates? Because I think we jumped in assuming everybody's ready. Okay, so the date, it's effective on the 1st of February. So your mandatory disclosure forms, your regulation 37 requirement that as a property practitioner, you need to, on your letterhead, on your marketing material, on everything that you do, your emails, everything, you need to say, I am a registered property practitioner with your Fidelity Fund Certificate number. Your EAAB Fidelity Fund Certificate for this year, 2022, is still valid. You run with him until next year, and then you will be issued a new Fidelity Fund Certificate then under the PPRA. But importantly, you need to register with the authority before the 31st of October. That's where Bruno's 31st of October came in. So you don't have time until the 31st of October to get compliant with your mandatory disclosure forms. That's happening now. That is happening on the 1st of Feb. So from the 1st of Feb, you need a mandatory disclosure form attached to every single mandate agreement, be it for a sale or a lease. And you need to attach your mandatory disclosure form to your offer to purchase, your sale agreement. If there was a property practitioner involved, best practice definitely would be to attach it to your lease agreement as well. And so that's happening now. And there could be a postponement on that, but I doubt it. We're sort of too far in for that. We only have one more publication of the Government Gazette in 3 days from now, before the 1st of Feb. So I think be ready and get them ready, but registration before the 1st of October. Okay, now I will keep that.
Oh, Cilna, that's actually such an interesting point as well, because I see from what I've been reading about the Act as well, it states that you could be liable for fine or imprisonment for not adhering to those specific, the regulations of the Act that you're referring to in terms of displaying the Fidelity Fund Certificate or having a valid one for that matter. So it is quite pressing, and we should, act on it as fast as we can.
And your risk of losing your commission, because remember, if you don't comply, you will have to pay your commission back to the PPRA, and they will resolve it then from there. So if you want your commission, rather play, urge your safety side. But maybe I'm just super conservative when it comes to these. No, I'm such a whiff, Macy.
It's worth mentioning. Sorry, now we're just trying to shove everything in here as much as possible before the 1st of February. But I know from a practical environment, a lot of people typically ask these questions. So estate agents they've got Fidelity Fund certificates. Some of them are asking, but wait, so what do we do differently now? Some of the things we discussed now are back-end things that typically your estate agency might do for you, especially if it comes to new applications, or make sure by the 31st of October, like your agency's in place. So like the guy on the ground is still going, how does this impact me? So there's a couple of things in the Act, and we don't have time to go through everything, but stuff that I noticed. Now, again, this goes back to what Cilna says about like sourcing agents. And I have actually always agreed that, as long as a sourcing agent is brokering a deal, and there are differences between people that source properties, literally go, oh, wait, people are selling here, let's get data and go give the data to somebody else. You're not a property practitioner, you're not brokering anything. You're literally like a data acquisition. It's the equivalent of going on Google and searching out a list of properties. But the actual brokering, facilitating a sale, that sort of thing, that goes a lot deeper than simply writing down a bit of information and handing it over to someone. Practical effect from estate agents on the ground is there's certain things now in the OTPs that you need to add into the OTPs, right? A specific clause that basically warrants that you are warranting that you have a FFC. What's interesting is, from a legal perspective, this changes the nature of the agreements that used to be simply an agent accepting benefits. Now it actually makes the agent a party to the agreement. So agents are now, they would have to sign the agreement, as opposed to in the past where one could say tacitly, I did accept the benefits of the commission. Now you'd have to sign this agreement. Things like displaying your Fidelity Fund Certificate, attaching the necessary information to the agreement itself. So some people are saying, listen, just attach the agreement as an annexure, just for the sake of it being there. Refer to it and attach it. And like Cilna mentioned, given all the uncertainties, rather be overly cautious than try challenge something for the sake of nothing. If you have a certificate and you've got an agreement and somebody goes, well, attach it, just attach it. There you go. It's Annexure A and it doesn't matter. Have the clause in the agreement. There you go. 100% perfect. And also from a practical perspective, those that are not registered as estate agents, get everything together by the 31st of October. It's a transition period. Plan for it. Reason being, and Cilna touched on this earlier, payment of commission. In the past, you got commission in your pocket. The people couldn't get it back from you, right? Now that's changed. Now you have to pay it back. So that's a big change from the previous piece of legislation that said, well, once you receive it too late, the matter's done. That doesn't apply anymore. And on top of that, to just make sure that something doesn't go amiss, conveyancers are now obliged to ask you for your Fidelity Fund Certificate before the payment of the commission actually takes place. So whereas you might think, well, the seller doesn't know, no one's going to complain, I'm just going to claim calm and there's going to be no issue. A lot of conveyancers have been doing this up until now, but now it's become a requirement for us to ask the question, which means that even though that conveyancer is your buddy and you feel close, that conveyancer won't have a choice, because if he does it and something happens, he's going to get into trouble. And no matter how much of a buddy he is, rather get your stuff in order than expect him to cross the line so that you can make money. So yeah, just a couple of little tidbits there of things that I think the guy on the ground is going to need to know.
Thanks so much, Bruno. I hope we have time just for one last thing or point that I want to raise, and well, I'm going to raise it anyway, is around the prescribed service providers, and in terms of how that impacts, myself as a property practitioner who's now offering incentives or whatever it may be for using a specific attorney or a conveyancer or so forth. I'm not sure if we touched on this previously, but maybe Cilna, you want to touch on that quickly, or Bruno?
Bruno, I must say on that one, I've been so focused on the rest of the thing and the impact on lease agreements. I'll be honest, I'm not comfortable enough to say something on that because I'm not fully comfortable there.
Look, I'm totally with you. I've also been focusing more on the practical implications. Yeah, the funny thing is, and as critical I am of the act, a lot of the stuff here, though, when it comes to prescribed service providers, it kind of goes along the notion of, if you thought you were doing something wrong, now they've just put it in writing. So things like kickbacks, for instance, at no stage was an estate agent supposed to be giving conveyancing to an attorney in exchange for some sort of reward. Only thing was, at that point in time, the estate agents, no one said anything to the estate agents about it. The attorneys were the ones that got into trouble for giving something to estate agents if they receive conveyancing. All that's happened now is it gets played on both sides. right?
Yes.
There is like incentive is very loose, and I worry about things like that. What is incentive? Is it only monetary in value? Is it kind? So, we're now going to delve into a far deeper world on what these, what these terms actually mean. And it is, I suppose it'll just get tested over time. I don't think initially people acting bona fide are really going to struggle. They're probably going to get a slap on the wrist going, listen, I know that, for example, you used to help out auctioneers by whatever, being at the auctions, and maybe something like that won't actually be considered bad, but we're yet to see. So let's, we'll deal with that. Maybe there'll be a slap on the wrist. There'll be a warning. Maybe there'll just be literally a notice that goes out, a news flash going, we consider this as wrong. So if you're doing it, please stop doing it.
Exactly, because it's always been the case, at least from the attorney's side, in our rules and our conduct, we're not allowed to give an estate agent anything in return for conveyancing. And yet estate agents, and we can say this openly, estate agents would easily say, you know what, I'm happy to send you conveyancing, but will you pay for our awards function and stuff like that? And luckily, I'm such a freaking goody two-shoes. I've always said no. But I don't think estate agents realized that attorneys were acting illegally by doing those things. So maybe just now all the parties know that that is very naughty.
Yeah, thanks, Cilna.
And I think the approach, honestly, the approach very often was the expectation, because if one party is not going to get into trouble, it's like, look, you want this, do it. And like Cilna mentioned, it became very difficult because for conveyancers, it's already a cutthroat environment. And now you're dealing with people that weren't feeling the consequences of those specific actions. Whereas now, if they're going to do it, both parties are going to be faced with a dilemma and consequences potentially, depending on the enforceability. Another prescribed service providers, and like I said, I haven't spent a lot of time on this, similar to Cilna, but I do recall there being a conversation around developers, or rather, let's say the limitation of what estate agents can practice within a certain complex, or as a developer, are you allowed to use only one agency or have an agreement for exclusive use of an agency? Can body corporates and HOAs have a restricted number of agents working within that area? So there's a whole bunch of stuff in this act and regulations pertaining to that. But like I said, I don't have the detail to be able to express an opinion.
But thank you so much, guys, for that. I think it was so interesting, especially for lay people out there who are not too familiar with this act, also to touch up on people who are familiar with it and certain aspects that, we want more clarity on. I encourage our viewers to please contact Cilna at SSLR, to contact the firm, and to contact Bruno at Bruno Simao attorneys if you have any questions about the Property Practitioners Act and its application in your daily work or in your life. So thank you, Bruno. Thank you, Cilna.